Who's excited about copyright in this room? Anybody? All right, good. And if you're not, you're going to be by the end of this. My name is George Taroni from the U.S. Copyright Office.
And I'm Katie Rowland from the Copyright Office.
All right, so what we're going to talk about copyright. What is copyright after all? Are there, I don't know, that was kind of not a fair question because I didn't really tell you what it was, so then I'm asking you, what is it? So let me get a feel for the room. Who in this room is a copyright owner? Any copyright owners? Oh, we have a few. Okay, congratulations. Very good. I might ask you that question again later, by the way, but that's just keep it in mind. So, what is it? What is copyright? You have seen, if you read books because you're here at the National Book Festival, right? So you've seen that little copyright symbol in a book, and you've seen maybe a copyright symbol at the end of a movie that you've been watching. You see it on my shirt because I love copyright. And you wonder what it is. And so copyright is, after all, there's the TV. Copyright is ownership in the wonderful things that you create. And by the way, even the not wonderful things that you create. There's no judgment. So whatever it is that you make, and it's an ownership, right? Some of you might own a car, you own a house, or you own different things. Well, those are property, and copyright is a kind of an intellectual property. So it's automatic though, right? So when you have an idea, and then you make that idea into something and fix it in some form, you get copyright. You're a copyright owner automatically, nothing else you have to do. Now there's a little bit more to it we'll tell you about, but the copyright ownership and the rights that come with it are automatic and they happen right away as soon as you express the idea in some way. And you've probably heard about trademark and patent. Those are also little symbols. We're not talking about that today. Those are other kinds of intellectual property law. There may be some overlap, but today we're going to focus on copyright. So it's a right. That's the first thing I'll mention. And by the way, that's R-I-G-H-T. Some people get confused and try to write copyright W-R-I-T-E. And I get it because it has to do with writing too. But this is a right. It's actually a whole bundle of rights, a whole packet, a whole basket, a whole bunch of rights, okay? And one of the very important rights, and historically really important, is the right to copy, right? So that's where you get that word, copyright. That's only one of the rights. There are actually a whole bunch of them, as I mentioned. There's the right to copy, okay, to make different copies of your work, to distribute it, to send it to people, to one person, to 20 people, to 1 million people. The right to create derivative works. Okay, so that's when you create something, and then later on, come along and create something based on that. It might be a screenplay based on that great novel that you wrote. The right to display. So when you take a photograph, you have the right to display that. The right to perform. There's a digital audio transmission right that has to do with transmitting things on the internet. So these are all different types of rights that you get as part of copyright. And they're yours, and you own them, and you can do things with them. You can sell them, you can lease them, you can license them. They're your rights, just like the right to your property, any other kind of property, but this is intellectual property.
All right, so I have a question for you before we go to the next slide. How many people know how old copyright is in this country? One person back there. So do you think it started in the colonies? Do you think it started when we had this federal government? Do you think it started in like the 1800s? Who here thinks colonies? Who here thinks when we became a country? And who here thinks in the 1800s sometime? Well, I'm going to tell you when it came about. So it actually is in the Constitution, believe it or not, but it actually predates that. So all 13 colonies before we had our federal government had a copyright law in each one. And when the founders decided to put together a constitution, in the actual Article 1, Section 8, Clause 8, it has what we call the Intellectual Property Clause, and it covers both patents and copyrights. And if we see on the screen, it's how to promote the progress of science and useful arts by securing for limited time to authors and inventors the exclusive rights to their respective writings and discoveries. And so one of the little funny things about copyright is that we're the science in there. The useful arts is the patent part. Something, weird language changes over the years, but that's where we are. And the way this works is that there was no federal copyright law right away because it said that Congress could make a law. And so Congress went ahead and made the first law in 1790. And so we were talking about the different rights that you have for copyright, and along with the copyright clause, the intellectual property clause of the Constitution, you notice it said that it was for the progress of the sciences and useful arts, and that means that the whole point of copyright is to kind of incentivize, encourage you to make things, make copyrighted works, so that everyone can read them and see them, and then eventually they go into what's called the public domain, which we'll talk about in a little bit, and at which point everyone can use them. And there are also some exceptions that everyone can use them from the beginning. But the whole point is to kind of create culture and create our national culture and create new things that people can use and read and enjoy. So that is basically the point. So here you have this person. He is a guitar player, it appears, and he is writing a song. And because he's writing a song, he's going to be able to get compensated for it, we hope. And then he will have enough money to maybe get a studio, to get people to help him, to go on tour. And so it's really a way to help him get his music out there. And this is another part of the point of copyright. So this actually is a strategic plan, which is super interesting and exciting, but I don't know if you all have read it. I mean, why not? But as you can see on there, it says copyright, the engine of free expression. And that is a kind of a tagline we're using right now, but where do you anyone know where that comes from? Do you think it came from the Constitution? Do you think it came from federal law? Do you think it came from the Supreme Court? Supreme Court, that's the answer. It came from the Supreme Court. So there was a case in the Supreme Court. It was actually about Gerald Ford's memoirs, and there was a fight over someone trying to publish like juicy bits of it before it got out. And in that opinion, Justice O'Connor said that copyright is the engine of free expression. So the whole point of it is to help us express ourselves and have a way to get incentivized and encouraged to do so. And so here is a little bit of trivia for you. Okay, so we're gonna tell you this in a minute, but before we get there, we'll figure out if you know the answer already. So for a work to be protected under copyright, it must be original, be of professional quality, include a copyright notice, or have a value of $35. Who thinks it is A? Oh, you're good. Who thinks it's B? Who thinks it's C? I think George already told you it does not need to, it can be really bad, and you can copyright it. And D, have a value of $35. Nobody. That is kind of a weird question because our cheapest registration is $35. But it is, as you all noticed, A, to be original. And George is going to talk about what it means to be original.
Right, so original, it's all about the spark of creativity. You are creating it. It comes from your mind onto something, onto paper, onto a digital form, onto a platform, a phone, a sound recording device, and that's it. It just has to have the idea and then the expression of the idea. So it's pretty simple. It means that it's independently created and creative. You have to have a spark, a modicum, a little tiny bit of creativity. It's not a lot, okay? A lot of things are registered by our office that don't have that much creativity, but as long as there's a spark of creativity and the idea that you have is realized in some way, then you got it, okay? And I talked about, that fixed form, okay? So back in the old days, I used to be very simple because it was just paper, right? That's how everything was recorded. And then, nowadays, things can be, a lot of things are recorded digitally, right? But that's also in the law considered to be a fixed form. And it takes lots of different forms. So it can be a book or a short story, that wonderful novel you're working on, poems, videos, and that's videos taken by a studio, movies, or it's videos taken on your phone, okay? Because we're all taking videos all the time. All kinds of movies, software that you create. And because of a very sort of odd circumstance in the copyright law, software is actually considered a literary work. But anyway, it's protected. Paintings, photos, and of course that's the high quality, wedding photographer photos and the news reporter photos, and also the photos that you're taking all the time and all your selfies, all the photos that you're taking. Music, and that takes the form of sheet music or the music that you create, and also sound recordings, so the recordings of somebody singing or any other kinds of sound recordings. So here's what I would like everybody to do. Did Bob tell you to, where's Bob? Did he tell you to put your phones away? Well, now I want you to take your phones out, okay? Everybody's gonna take your phone out, all right? Got your phones out. So what I want you to do now is to take a picture of us. Yay! So everybody ready? Are you gonna, on the count of 3, I want you to take a picture of us. 1, 2, 3. All right, great. Yeah, Katie doesn't like her picture doing take, but now I've forced this to happen. Okay, so congratulations. So how many copyright owners are in the room right now? Raise your hands. How many copyright owners? All of you, right? Because you all just took that picture. So you all created a copyrighted work. So go ahead, Instagram and Twitter and Facebook that. Hashtag National Book Festival, Nat Book Fest actually is what it is, hashtag Nat Book Fest. You can go ahead and tweet that out because it's yours, you own it, right? You have the right to copy it, you have the right to distribute it, remember? And it's your copyrighted work, and you created it in that fixed form. So that's pretty amazing, right? It's pretty easy to own a copyright because you just did it. And now you realize, right, that you've owned copyrights forever, because you've written lots of things and you've taken lots of pictures and maybe you've recorded a song and maybe you've written a poem. So you have a lot of copyrighted works, every single one of you, which is really great. Now, here's a little fun fact. So you each took a picture, right? And you each own the copyright in the picture that you took. Even though if we were to look at all those pictures, they're pretty similar, right? You might not be able to tell one from the other, but you did have a little spark of creativity, right? Maybe you cut me out of it. Maybe you zoomed in. Maybe you took a selfie instead. I don't know, but there was some creativity, a little spark, and so that way you own that copyrighted work, and even though it's very similar to the person sitting next to you and the work that they took. So that's kind of an interesting happenstance of copyrighted works. So congratulations.
All right, and I think we have another, this is the picture that you probably took, and we have another question, another trivia question for you. So we will explain it to you a little bit more in a second, but to kind of see where you guys are, here is the question. What is not protected by copyright? Is it A, ideas, B, facts, C, procedures, or D, concepts? So who thinks it's A, ideas? Who thinks it's B, facts? Who thinks it's C, procedures? And who thinks it's D, concepts? Okay, we kind of gave you a little bit, whoops, it didn't work.
Go back.
I have to go back.
Oh, because it's wiggling now.
It's wiggling, oh, sorry, it wiggles. I can't make it wiggle. I'm not great at the wiggling. Here, let's see if I can make it wiggle. Ah! Anyway, they were all wiggling. I promise you they were. You saw them wiggle. That means it's a trick question. None of them are copyrightable. So ideas, facts, procedures, and concepts, none of them are copyrightable. And some of those things might be copyrighted by, protected by other laws. So for example, patent law might cover procedures and, kind of methods, that kind of thing, but that is not the part that copyright covers. And one thing that I guess I will say quickly is that sometimes something is protected by more than one kind of intellectual property. So you can have something that's covered by copyright and trademark, or a copyright and a design patent, or sometimes all three, design, patents, copyright, and trademark. So they're totally different, but sometimes they all kind of like are in one thing. Okay, so not copyrightable. Here are some more things that are not copyrightable. So fonts. So if you think of like, whatever Times New Roman or whatnot, that is not copyrightable. Although there's a little catch, which is if you make a software program to create a font, that software code can be protectable. But if you don't use that code and you use something else, you can use that font. Short words and phrases. So for example, if you have a title of a book, my daughter over there really loves Dog Man. So if you had on the book Dog Man, that could maybe be not something else, but it cannot be copyrighted. And sans affaire. Sans affaire is a fancy French way of saying common themes, common ideas. So, you think of a boy meets girl and they fall in love, like that kind of idea. Or that a detective is always wearing kind of like a trench coat. Those kind of things are called sans affaire, and those are not protected by copyright law. And so then the question is, how long does a copyright last? So here we have another piece of trivia for you, so you can find out. But I will tell you it has changed over the years. So I'll tell you what the first one was as soon as we go through this. So how long does copyright last? Is it 75 years from registering the work? Life of the author plus 50 years? Life of the author plus 70 years? Or 100 years from registration? So who thinks it's A, 75 years from registration? Who thinks it's B, life of the author plus 50 years? Who thinks it's C, life of the author plus 70 years? And who thinks it's D, 100 years from registration? So it is C. That's correct. That's the right answer right now. It is the life of the author plus 70 years. That is for individuals. There's a whole other kind of way of doing it for corporations and works made for hire. It's a different thing because they don't have a lifespan, so you can't do it by their life. And this has changed over the years, so it actually only became life of the author plus 70 in 1998. In 1998, it was right before, it was life plus 50. And actually, when it first started, it was 14 years and a renewal of 14 years. So it's kind of changed over the years. We don't have a renewal term anymore. Now you just get it, and it lasts. Okay, and I think this is for George. We'll explain more.
All right, so we talked about copyright, and we want to talk a little bit about the U.S. Copyright Office, where both Katie and I work. And what does it do, and why does it exist, and what's the purpose of the U.S. Copyright Office? Well, for one thing, it's been around a long time. So another trivia, and I like the trick questions, so you probably noticed that. So this is another sort of trick question about how long the Copyright Office has been around. So who thinks 1790? 1790? 1870? Any guesses for 1870? 1897? Or 1909? Anybody? 1909. So 1790, 1870, 1897, or 1909. So here's the trick. There are actually kind of two right answers, right? Okay, so here's why. So in 1870, the Library of Congress became responsible for registering copyrights and administering a large part of the copyright law, doing the business of copyright, as it was referred to at that time. And then the library was swamped with copyright registrations and books coming in, and the librarian begged Congress, said, please give us more people and more resources. So in 1897, they created the U.S. Copyright Office as a separate department of the Library of Congress with its own head called the Register of Copyrights. It's a very formal title. And so we have these two dates, but we really like the 1870 date because if you do some quick math, you will see that next year, in 2020, we will celebrate our 150th birthday, our sesquicentennial, okay? So that'll be on July 8th. And we want you to keep an eye on us. By the way, copyright.gov is our website. That's the first time I'll say it. I'll probably say it like 2 or 3 more times. Copyright.gov, and you can find out all the wonderful things we'll be doing to celebrate our sesquicentennial of copyright at the Library of Congress. So what do? at the Copyright Office. We do a lot of things. We administer parts of the copyright law, and one of the very important functions is we register those copyrighted works, like the ones you just created. And why do we do that? Well, registering your work with us creates a public record so that way people know you're the owner of that work. Okay, that's pretty important. There's also another great benefit to registering your work with us. If someone uses your work without permission, you can take them to court. But before you take them to court, our office has to register or refuse your work. So register your work first, then go to court. But if you don't register, then you can't go to court, and then you can't defend your infringement case. So that's a great benefit to registering with the U.S. Copyright Office. And we register a little over 500,000 claims, which contain many millions of works every year. So it's a lot of work that we do. And so we encourage you to do that, to register with us. Then I mentioned about the infringement. That's done by a court. A judge decides whether or not there's infringement. You've probably heard about famous cases. They make the news, especially around music, where one song sounds like another, and then they go to court, and the judge has to decide, not only do they sound alike, but was there really infringement? Did somebody have occasion to hear one work and adapt it for their own? That's up to the judge to decide. So our office also records ownership transfers. So I mentioned before that you have all those rights, right? Copy, distribute, display, and so forth. And you can sell them, and you can lease them, and you can use them in a license agreement. And you can have a legal document that you record with us, because when you write that screenplay and then you want to sell it to a movie studio, you're going to want to record that in a legal document. You can record that document with us, and then people know that you have sold that right or leased it or used it in a loan as a collateral. There are all kinds of things you can do, but that's the business end of copyright. It's a $1.3 trillion industry in the U.S. That's a lot of money tied up in copyright industries, and so we're here to support that. And another thing that we do a lot of is educate the public, which is why we're here today. And why? Because copyright law has changed a lot. Okay, in 1790, here it is. It was 2 sides of a page. This is not the real thing. The real thing's at the archives, by the way. They wouldn't let me take it. Okay, but this is it. It was 2 pages of a sheet of paper, and it protected books and maps and charts. Okay, and that was the copyright law. Probably sufficient at that time, because there wasn't all kinds of digital downloading going on, and Spotify didn't exist in 1790. Nowadays, this is the copyright law, okay? This whole volume right here. But here's the good news. You don't have to learn this. We're here to help you, okay? You go to copyright.gov, and we have lots of resources that help you understand what parts of this law apply to you. And when you're registering your copyright, you can go to our website, you can call us. We will give you the information you need to know. We're not going to give you legal advice, but we're going to steer you to the right information. We have bite-sized information for you. So that's why we're here, to help you figure out how you can connect to the copyright law and how you can benefit from it. The other thing that happens with the books and other materials that come in through copyright registration is that a lot of them become parts of the Library of Congress collections. So the Library of Congress builds a lot of its collections based on your copyright registrations and other things that come in for deposit. We call that deposits. Those are the things that come in to the Copyright Office, and some eventually to the library.
All right, so now we have talked about the rights, and we're going to talk about how you should use works that are copyrighted that might not be yours. So important to be a responsible copyright user. So if you look at something, don't just copy it wholesale and start selling it or printing it on a T-shirt or something. Make sure you pay attention to what is going on. And there are certain things that you can do without permission, though. And there are a lot of exceptions in the copyright law. So there are certain ones for libraries, there are some for people who are blind or visually impaired, and there's something called the first sale doctrine, and that is the thing where if you have like a book and you sell it to somebody else, you can do that. Because the copyright itself only is the thing, the kind of expressed idea, it's not the physical thing. So if I was to sell a painting, you can hang that painting in your house, but I am the one who can make the posters of that painting. You cannot. So there are kind of different exceptions, but the biggest one that everyone thinks about is fair use. How many of you have heard fair use? Great. It is a cornerstone of our copyright law because, as you know, we have the First Amendment. And the First Amendment is obviously incredibly important in the United States. And fair use is one of the ways that we make sure that we don't kind of tread off against the First Amendment. So it allows certain uses that will not run afoul of other copyright provisions. And we are going to give you a special treat now. This is the world premiere, if I can get it to work, of our video. So we're in the midst of making a bunch of little videos about copyright and facts and information. So we actually have one on fair use. And so I'm going to show it to you. And you are the first people who are not like us to see it. So here we go. Let's see if I can. Oh, you're going to do it? Okay.
So what is fair use? Fair use is a case-by-case test found in copyright law. When met, it allows a use of a copyright-protected work without permission. For example, using a quote from a book in an article may be a fair use. The fair use concept is central to copyright law and helps promote freedom of expression and innovation. Let's look at some basic concepts. There is no formula to ensure that using a particular amount of a work will qualify as fair use. Also, it's not as simple as declaring, "I think my use is fair." While the law gives some examples of things that are traditionally fair use, not all uses that fall under these categories are actually fair uses. And some specific uses that do not fall under these categories have been found to be fair uses. Fair use is a case-by-case inquiry. We have to analyze each use of a work. Essentially, fair use asks us to think through our actions. Federal law sets out 4 fair use factors. The first evaluates the purpose and character of the use. An educational, non-commercial, or transformative use is more likely to be considered fair. A transformative use adds new purpose, meaning, or message not present in the original, as opposed to merely replacing the original work. A use that merely replaces the original use or purpose of the work is less likely to be considered fair. The second factor considers the nature of the copyrighted work and will favor fair use if the work is factual or previously published. Here, consider copyright's purpose to encourage creative expression by providing exclusive rights to authors. The third factor evaluates how much of the original work is used. In addition, pay attention to the importance of what was taken from the work. Are you using a lot of the original work or the heart of the work? Taking too much when not necessary is less likely to be fair use. The fourth factor analyzes whether the new use harms the existing or potential market for the original work. Fair use requires an analysis of all the facts and factors. The factors may point in different directions and may not lead to a clear result. It is important when thinking about fair use not to jump to conclusions. Only a judge can make an official determination of fair use. This usually happens during an infringement case. Sometimes it can be hard to rely on fair use, especially if there isn't a lot of case law available. Finally, if you don't know if a use is a fair use, you can always ask for permission from the copyright owner. If you decide to rely on fair use, be thoughtful and deliberate and keep these core points in mind. To learn more about how fair use is applied in different situations, visit the Copyright Office's Fair Use Index.
Hey. We're going to mention the fair use index a little bit more.
Going back to our slides. All right, we're going to skip. All right, so that was a lot there. There's a lot about fair use, right? But you don't have to remember it all right now. Copyright.gov, remember, we have our fair use index. We're going to have this video soon. So I think the takeaway is that you do have to put a little thought into it, okay? Do a little research, think it through, and use our website, copyright.gov, and you'll learn more about it. So there are some other ways that you can use materials responsibly. For example, if something is in the public domain. Have you heard about the public domain? Anybody's heard about that? Yeah, okay. So that means that something is free to use. Works created by U.S. government employees in their duties, those are in the public domain. Works prior to 1924 are in the public domain. And from now on, that started this year in January, every year it's going to tick one year forward. There are some works that were never protected. They may be in the public domain. So there are things to think about. To be a responsible user, is it an educational use? One thing that you can rely on, if you're absolutely sure that something is protected, if you want to use that Taylor Swift song in your work and you're basically taking the whole thing, ask the person who owns the copyrighted work for permission. You can always ask, and so that's a good way to go if you're relatively sure that fair use and public domain and other things don't apply. So you can always ask permission. So we have just a few minutes more, and we are open to your questions. And we have microphones over here. If you have any questions for us, we'll be glad to answer them. Questions? No questions?
I'm Brian Marcus. I wanted to ask, it's been rumored that if you have, say, a manuscript or something that you mail to yourself, that actually counts as being copyrighted.
I didn't even have to hear the whole question. That is called the poor man's copyright. So if you've ever heard of the poor man's copyright, that is not a thing. So that is when you write your manuscript and you mail it to yourself. And is that a registration? Does that do something special? No. That does not give you a registration. You have to register it with the United States Copyright Office. You will have copyright protection if you wrote it down anyway. I think some people do it and they think like, oh, I sealed it up and now it's totally mine and no one else used it. But it's unfortunately, it is not helpful.
With regard to older copyrighted material, does the library maintain a registry? Like, if I was looking up a movie that was shot in the 1940s, how could I reach out to you all to find out who the copyright owners of this would be?
Copyright.gov. So, yeah, so if it's from 1978 up until today, there's a very easy to use search capability. You can look by claimant or by title. The works older than that are on 36 million catalog cards, but we have recently digitized them and put them online. They're in a kind of a rudimentary search system. You can't use full text searching like you would in Google, but you can browse through the drawers as if you were looking through a card catalog. So it is possible to find things, and they're indexed also. They're the index of copyright registrations, and they go all the way back to the beginning. So you can do that. So thank you for asking that.
Oh, did it turn off? Oh, there we go. Hi. So I had a question, more of a policy question. You talked about fair use and the first sale doctrine, but those only apply, the first sale doctrine only applies to physical copies of copyrighted material. Software and digital books can only be licensed, and so the waters get a little murky in that respect. What is the copyright doing just sort of policy-wise about trying to figure that out?
That is a great question. We actually have a report on software and actually it's consumer products. And this has come up a lot because you're correct. A lot of software companies will license their works and now they're doing it online as well. So instead of getting the CD, you go and you get like a yearly fee that you have to pay. And they have always kind of used this licensing construct to get their stuff out. They say that they're not selling it per se. So this is kind of exploded recently because now we have software at everything. So if you think about your refrigerator, you might not know this, but there's some little software telling you how like the cubes should be coming out or whatnot, or your thermostat, or those kind of things, the windshield wipers, all these things that before were completely mechanical now have software. So it is something that we are exploring. We have, and I will tell you about this later because it's kind of in the weeds, but there's this thing called Section 1201, which goes into that. Every 3 years, we provide certain exemptions. And we also have been looking at it very deeply because we know that it's kind of going everywhere. So it was, I guess it was 2016, I think it was September, October, November. 2016, we have a really awesome report that I co-authored called Software and Consumer Products. So take a look at that. It's like 100 pages, but it is really actually, for us, pretty succinct.
Yeah, cool. Thank you.
My question deals with ownership of copyrights. You indicated that an author can register their work with the Copyright Office, and you also touched upon assignment. What is the significance of assignment? And to phrase my question, I might give a hypothetical. Author A assigns his copyright to B. B does not record the assignment in your office. Later, A assigns his copyright again to C. C does record in your office. Who wins?
Well, that's a good complicated question there. But by the way, both registration and recording of assignments, they're both optional, okay? But it is up to the parties involved to follow the law, right? So yes, somebody can assign their work to someone else, but if they've assigned it to a third person without telling that first person, that might be something that they'll have to fight out themselves. We wouldn't get involved in that necessarily, but we will serve as the Office of Public Record of any of the documents that are involved.
And I'll say so. Basically, we don't have a procedure in the Copyright Office to determine who is and who is not right. So anyone can, file these things, and if they swear under penalty of perjury, we'll take their word for it. And if there's more than one, we will not kind of adjudicate that. They have to go to court to kind of work that out. So we don't have a process where we say, oh, you're the owner, or you're the owner.
All these rules make a lot of sense, and they've been around for, they've evolved over a couple hundred years. But isn't the problem really a question of enforcement? Because for an average copyright owner, now, if something's going to get stolen, if you write a book and it gets published by someone on the internet, you have no idea who even did it. Unless you have hundreds of thousands of dollars and 10 years to go through the court system, you have no hope of ever finding those people. So it's kind of all of this, with all respect, because I think the system's great, but isn't it kind of irrelevant? Because all the damage economically is done. Everybody can read the book, everybody can read your work, see your work, hear your song, and there's nothing you can do to put the cat back in the bag. Isn't that really the situation that we're in today?
Okay, well, that is a very good question. You're right. So, to one respect, so to get a copyright infringement lawsuit, it's all federal court. You can't go to state court. And like state courts have like small claims courts. There's no such thing in the federal court system, and federal courts can be very expensive. So right now, you would hope to get some pro bono. That means free representation from a lawyer. There are kind of entities called Lawyers for the Arts, and a lot of clinics at certain universities. That is kind of where we are right now. However, there is legislation pending right now that would provide for a small claims tribunal within the Copyright Office, where you could go for claims under $30,000 to go to kind of this kind of arbitration panel that would be in the Copyright Office. It's under this thing called the CASE Act, which is not passed. It kind of went out of the Judiciary Committee, I believe, but it's kind of sitting around for right now. Maybe it will go somewhere, maybe it will not, don't know. But that would be one way of kind of making it easier for people to enforce their rights.
But it still presumes you knew who stole it.
Yep, you do have to do that, and that's kind of a problem all over the place.
You kind of touched on this earlier.
Okay, now our last question. I'm told we have to wrap it up.
Oh,
Thank you.
You kind of touched on this earlier when you mentioned the software and a yearly fee. If you get a written piece copyrighted, is there a yearly fee that accompanies that as well?
I'm sorry, yearly fee that does what?
If you get a written piece copyrighted, do you have to pay a yearly fee once?
No, you only
Okay.
pay once. You register the work, and then it's good for the lifetime plus 70 years.
Fantastic. Thank you.
Okay, well, thank you very much for coming to listen about copyright, and I hope you're all excited about it. And where are you going to go? Copyright.gov, right? All right, thank you.